Welcome to the NewsHour. With just one day left in its term, the U.S. Supreme Court issued a trio of major decisions today.
The justices upheld a law making it a crime for unhoused people to camp in public areas like parks, sidewalks, and plazas. They narrowed the scope of a law being used to prosecute the January 6th rioters and weakened the rulemaking powers of regulatory agencies. PBS News Weekend anchor John Yang reports on the Supreme Court for us. He's here now to break it all down. John, good to see you.
Good to see you.
So let's start with the case of Joseph Fiser. This is a man charged with 7 counts after storming the Capitol on January 6th. What aspects of his case did the justices consider here?
Well, Fiser challenged just one charge that was against him, that was obstructing an official proceeding. Because of the way the law is written, his argument was it had to involve an actual document, a piece of evidence. Now, the justices agreed that it didn't cover storming the Capitol or confronting police officers inside the Capitol. Chief Justice John Roberts said in the majority opinion that the way the Justice Department is using the law criminalizes a broad swath of prosaic conduct, exposing activists and lobbyists to decades in prison. It was a 6-3 decision, but not ideological. Ketanji Brown Jackson was in the majority, and Amy Coney Barrett wrote the dissent. She said the majority did textual backflips to reach their conclusion.
John, as you know, there are some 1,300 other January 6th defendants. How might this ruling impact those cases?
It appears to be quite limited. This is former Justice Department official Mary McCord.
That's because, first of all, only 346 of the more than 1,400 defendants charged for the riot and the attack on the U.S. Capitol were even charged with that offense. Of those, the vast majority are charged with another felony. So whether they went to trial or whether they pleaded guilty, they could be resentenced to a similar term of incarceration based on that other felony. There's a very few number of people who either were not convicted or found guilty of another felony, or it was only a misdemeanor, and those are the people who might get a resentencing.
Now, it's also one of the charges against former President Donald Trump, but some are suggesting that may not have to be dropped because his case does involve documents, those fake elector ballots.
Interesting. So there's also a separate decision I want to ask you about in which the conservative majority upheld an ordinance in a small Oregon city that basically criminalized behaviors associated with homelessness, things like sleeping in public parks, et cetera. So what were the key factors that they were considering in that case?
Well, the challengers said that these laws criminalized, they were punishing people for being homeless, for being unhoused. And you can't punish someone for their status. You can only punish them for their conduct. The 6 conservative justices said that's exactly what these laws do. They punish conduct, not status. Now, the liberal justices disagreed very strongly. Listen to the opening lines of Sonia Sotomayor's dissent, which she read from the bench this morning. She said, "Sleeping is a biological necessity, not a crime. For some people, sleeping outside is their only option. For people with no access to shelter, that punishes them for being homeless. That is unconscionable and unconstitutional."
John, what kind of reaction has that decision been getting from city leaders, mayors on the front lines of this issue, and also public housing advocates?
Well, a lot of the city and state leaders who've been struggling with this rather welcomed it. Here is Seattle City Attorney Ann Davison.
This decision will help with safety. For us, we had a nexus with gun violence at encampments, and so that was shown through our police data. Now, local decision makers who understand the unique circumstances in their communities are able to make laws that are responsive to what their needs are, instead of following something that might be better for a town that's thousands of miles away.
On the other hand, housing advocates say this is just going to make things worse. Here's former Housing and Urban Development Secretary Sean Donovan. He now runs the Enterprise Community Partners, which is a nonprofit trying to expand housing stock.
Criminalizing homelessness doesn't work. In fact, it makes it worse. In part, it's a game of cruel whack-a-mole. If folks don't have a place to sleep, no home, no shelter, just moving them or putting them in jail, those tents, those encampments are going to turn up somewhere else. But even worse, by arresting people, by fining them, you actually make it harder for them to find jobs, to find housing, the things that end homelessness.
John, meanwhile, in another decision, the conservative majority overturned a decades-old precedent. That decision effectively limits government agencies' authority to write rules. It's kind of dry stuff here, but help us understand the massive potential impact here and also why this has been on some conservative wish lists for quite some time.
It's something called the Chevron deference. It's called that because it first arose in a 1984 case dealing with Chevron. It says that if a law is ambiguous, the courts have to defer to the agency's interpretation of that law. Now, conservatives have hated this. They've been gunning for this for a long time. They call it the government always wins doctrine. Today, the Chief Justice John Roberts struck it down. He said that the law requires judges to independently evaluate agency actions and that justices or judges shouldn't defer to the agencies simply because the law is ambiguous. Now, this is, as you say, a big deal. This has the most widely cited precedent in U.S. jurisprudence. The underpinning of about 17,000 federal regulations dealing with the environment, with drugs, with food safety, everything.
Huge potential impact there. John Yang, after a busy week at the Supreme Court, thank you. So good to see you.
Thank you.